Good afternoon. My name is Jessica Tillotman, and I am the Associate Dean for Government Procurement Law Studies at the George Washington University Law School in Washington, D.C. We are hosting a wonderful webinar today on the new proposed organizational conflict of interest rule, and we're delighted to see everyone who's joining us. We are particularly pleased because we have nearly 700 registrants for this program from over 50 countries. So whatever that translates to who's actually joining us live is a little bit different, but we're really pleased to see so much enthusiasm for this. As I said before, I'm the Associate Dean for Government Procurement Law at GW. I also teach the law school's anti-corruption and compliance course in government procurement. I am thrilled today to be joined by an incredible lineup of speakers and experts in this area of the law. Kenneth Patton is the Managing Associate General Counsel of the U.S. Government Accountability Office. Kara Sacolato is a partner at Wiley LLP. Michael Tragle is the Senior Associate General Counsel at the Defense Logistics Agency. He is also an adjunct professor here at GW Law School, where he teaches or co-teaches our bid protest class. And then last but certainly not least is my colleague Christopher Eukins, who is a professor of government procurement law and teaches our government procurement reform course, among many others, at the law school. Please note that all of our panelists are speaking in their personal capacities and not on behalf of their respective organizations, but they may supplement what I've just said with a more specific disclaimer, so stay tuned for that. Finally, just a brief reminder that the focus of today's webinar is on the substance of the proposed rule. It's not necessarily on things that are in the news or regarding specific entities or contractors. So we're going to thank in advance GW Law 3L, Brian Duwan, who will be moderating our Q&A to make sure we stay on topic because we just have 1 hour to get to it. All right, so some brief background today. Competition is a primary goal of the U.S. federal procurement system to ensure that federal procurements are not undermined by something called conflicts of interest. The Federal Acquisition Regulation, or FAR, which is basically the rule book for U.S. federal procurements, addresses conflicts 3 ways. The first is a general prohibition at FAR 3.1. The second is a prohibition against personal conflicts of interest at FAR 3.11. And the third, and the subject of today's webinar, is rules relating to organizational conflicts of interest found at FAR 9.5. I'm going to let Ken take it away and explain what that is in greater detail in just a moment, but you should know that we've regulated organizational conflicts of interest for many decades, but in response to a 2022 statute, the Preventing Organizational Conflicts of Interest in Federal Acquisition Act, the FAR Council in January published a new proposed rule which may dramatically alter the OCI framework. So that's our subject for today. We're going to turn it over to Ken to kind of kick this off and really explain some background. What is an OCI, and what is the current landscape with how the federal government approaches these things?
All right, just getting off mute. Thank you, Jessica, and good afternoon, everyone. As Jessica mentioned, conflicts of interest are spelled out in the Federal Acquisition Regulation, but one of the important things to consider about this particular area of the law is that organizational conflicts of interest have a negative effect on the integrity of the procurement system. They erode trust and confidence in the ability of the government to receive goods and services in quality. And to that end, the FAR requires contracting officers to mitigate potential significant conflicts of interest so as to prevent unfair competitive advantage or the existence of conflicting roles that might impair a contractor's objectivity. Now, GAO and the courts have distilled the current framework from the FAR into 3 general types of organizational conflicts of interest. Those are biased ground rules, unequal access to information, and impaired objectivity. So what is a biased ground rule OCI? A biased ground rule OCI arises where a firm, as part of its performance of a government contract, has in some sense set the ground rules for the competition from another government contract. In these cases, the primary concern is that the firm could skew the competition whether intentionally or not, in its favor. What is an unequal access to information OCI? An unequal access information OCI arises where a firm has either access to non-public information as part of its performance of a government contract, and where that information may provide an unfair competitive advantage in a later competition for the government. And lastly, what is a impaired objectivity? An impaired objectivity arises where, because of the performance in one government contract, a contractor's ability to provide objective advice and assistance is somehow impaired because of some relationship. Now, these principles are not clearly laid out in the FAR, and as such, contracting officers typically need to consult with agency counsel, to make sure they have properly identified the potential OCIs in their procurements. And once identified, they actually have to address them. So the tribunals that manage and help agencies resolve these bid protests that occur as a result of these organizational conflicts of interest typically occur under three very broad categories of situations. The first occurs during a protest. That is, the contracting officer typically isn't aware of the conflict, but as a result of someone filing a protest, becomes aware of the conflict. After they become aware of it, the contracting officer will typically investigate and try to mitigate or resolve the conflict. The second situation occurs where a contractor is aware of an OCI, conducts some type of analysis to address the OCI, but uses the wrong criteria, either because they're unaware of what the underlying OCI really means, or they're unaware of how to apply the standards that have arisen during the cases from the Court of Federal Claims and GAO. The third situation typically arises where a contracting officer is aware of an OCI, analyzes the conflict, but fails to conduct a meaningful analysis about the conflict, or reaches the wrong conclusion because there's not enough evidence in the record to support this conclusion. So this brings us to why we're here today, to talk about the new proposed OCI rule. The rule provides explicit criteria, examples, and most importantly, contract provisions and clauses that contracting officers can use to help them address OCIs. The rule somewhat restructures the analysis that the court and GAO have laid out over the years from 3 types of OCIs to 2. Specifically, it proposes that there are impaired objectivity OCIs and unfair competitive advantage OCIs. And under the unfair competitive advantage type, there are 2 subcategories: biased ground rules and unequal access to information. So you still have these OCIs, but they're restructured and reframed in the new rule. So like any rule, time will tell whether or not and to what extent these rules are flushed out. I imagine the community will need to look at them and think about the various situations where these situations can arise under the new rules. I think one of the new provisions in the rule is somewhat significant. That is, the new rule actually allows contracting officers to address organizational conflicts of interest. The current rule requires them actually to mitigate and resolve conflicts of interest, which is slightly different than what they're typically used to doing. So with that, I think we're going to turn it back to Jessica to sort of kick us off and get us started in resolving and answering questions that may arise from this new provision.
Thanks so much, Ken. I appreciate that great overview, especially for those of us that are newer to this area. All right, so I'm going to turn it over to Mike first. Kind of what are your impressions of the proposed rule, what it does, and kind of how it impacts this area of the law?
Thank you, Jessica. Good afternoon, everybody. Again, I'm Mike Tragle with the Defense Logistics Agency. I'm also an Army officer, as you can probably tell. I do have to foot stomp, as Dean Tillotman mentioned. I am a government employee, but I am not speaking on behalf of the government, the DoD, or any other organization. These are my personal opinions alone. And I come at this primarily, most of my background is as a litigator, defending bid protests before GAO, for example, among other things. So I approach this kind of with the thought of how is this going to help me or hurt me when defending a bid protest, or how is this going to affect the protest landscape that we see? So I'm not going to speak to it too much from the side of what we call the formation side, where you're advising the contracting officers as they go through these processes. But my experience is dealing with the litigation consequences of some of these issues. But as Mr. Patton described, and if you've read the rule, or the new proposed rule rather, it all sounds very familiar. And it's not a coincidence that what Mr. Patton described is very closely mirrored in the new proposed rule, because we've been operating under this framework for years, for as long as I've been a contracting practitioner. And the new proposed rule isn't a dramatic departure from that. It just codifies and puts everything in one place, which is very valuable, because under the previous scheme, where all the rules were very similar, but you had to piece them together. You had to piece them together from the GAO decisions. As Mr. Patton mentioned, the contracting officers would be talking to their counsel to say, well, what's the rule on this? Where do I find this and that? And there's more opportunity for things to be missed. There's more opportunity for things to be misunderstood. And the decisions themselves aren't always clear. And that's not a knock on the decisions. That's just the nature of the beast, because GAO or the courts are interpreting the question that's before them. And they may come up with a rule or a framework in which, for instance, hard facts are required to support an OCI. But then you have to maybe go somewhere else to figure out, well, what do we mean by that? So one of the great virtues of the new rule is that it's all in one place. It's relatively step-by-step, and hopefully easier for contracting officers to follow and adhere to and understand. Because as Mr. Patton referenced, sometimes you miss something. Sometimes you evaluate it under one lens, impaired objectivity, for instance, when you really should be looking at an unequal access or something to that effect. This gives you a step-by-step method to walk through all of the considerations or most of the considerations. There's no rule that's going to cover everything, but this gives you a contracting officer a sort of a step-by-step process. Sort of if-then statements. If this is the case, then I go here. If that is the case, then I go there. If this situation is present, then I include this clause. That's another important change from the previous framework. FAR 9.5, the current OCI provisions say we should address these things through contract clauses and other such provisions, but they don't provide any. Now, the proposed rule changes that and very clearly says, if you think there's a potential for OCI, put this clause in the solicitation. If you think if there's a mitigation plan involved, make sure you put the mitigation plan incorporated into the contract. That's not a new requirement, at least in DoD, because it currently exists in the DFARS, but now it is uniform and required for all agencies everywhere. Sort of a general theme I kind of take from this is that there's a bit of shift in responsibility. The prior rules mostly put it all on the contracting officer. As Mr. Patton mentioned, it's the contracting officer shall resolve a conflict of interest. Well, oftentimes that's not within their power to resolve. You would need the contractor or outside entities, organizations, and individuals to do certain things in order to make it work. Whereas now the issue is the requirement is that they address it. Now, obviously, that's not a ironclad term that has the same meaning to everyone, but it does give some guidance as to how you can address it, specifically by avoidance, limitations on future contracting, mitigation measures, or acceptance of risk or waiver. And that gives a little bit more flexibility, a little bit more room to work while also providing more structure, because I don't want to call part 9.5 vague, but it's not as clear as it could be. And there are certain things that are open to or sort of generic and open to interpretation. And for us, for government practitioners, that's a double-edged sword. On the one hand, we love deference to the contracting officer, right? Regardless of how that landscape may be changing under recent precedent, We love deference to the contracting officer because it gives us the ability to use judgment and be a little bit subjective. But at the same time, clear standards and clear processes and clear rules help us get it right the first time rather than sort of floundering in the dark, because a lot of times it's in the eye of the beholder. What the contracting officer may think is right, what the contractor may think is right, and what GAO may think is right, all based on the same provisions, could be very different things. So overall, I'm encouraged. I like what I see, but there are some areas of potential ambiguity, and I can see some certain new requirements and new provisions that could lead to additional litigation. But generally, I think it's a step in the right direction.
Thanks, Mike. All right, Cara, you're up.
Thanks. Hi, I'm Cara Sacalato. I'm a partner at Wiley Ryan. My practice is kind of a mix between litigation and compliance. So I come at this, from two different angles of, how will this affect the bid protest system, and then how can contractors comply with this? And so when I've also been thinking about when I think about the things that I dislike about the rule, and there are things that I like and there are things that I dislike. I want to be sure if anybody, in the FAR Council might happen to be listening, is to be aware of the danger of unintended consequences. And I think about how, the SAM registration rule was revised a few years back to allegedly deal with an inconsistency about when you had to be registered in SAM. And a rule was adopted that was supposed to address that inconsistency, but led to essentially a trick whereby protesters were saying that if your SAM registration lapsed anywhere at any time for 1 minute during the course of a procurement, you would be disqualified. And the FAR Council had to come back in and fix that because that was not what they intended to do. And so bringing it back to here, I look at the clauses and I am worried that we are going to have a lot of unintended consequences arising from these clauses because of a couple things. Really vague terms of what has to be disclosed and the representation that is being made. And then secondly, there is a 5-day deadline for updating this pretty broad disclosure obligation if you get, if there's a change in any relevant facts. And so these are, I'll start with the vagueness concerns that I have with the disclosure obligation. The clause, when it is included in a solicitation, and let me just say, just like Michael, this is just Cara talking here. I'm not speaking for Wiley. I'm not speaking for a client. This is just me as a procurement person who has been in this industry for a while. The disclosure would include whether you're aware of within the past year, 12 months, present or currently planned financial or other interests that could result in an organizational conflict of interest, including information about affiliates, clients, and potential subcontracts. Okay. I don't know what currently planned means. It's not defined. I don't know what that means. I don't know what currently is, and I don't know what planned is. Financial. I don't know what financial means. I can think of examples of what it could be, but I could think of, how broad are we going to cast these nets? Other. I don't know what another interest is, that could literally be anything, your clients. I think they are trying to get at, and I understand why, commercial or foreign government clients, but currently planned financial interest in a client is pretty darn broad, and I don't know what is meant by potential subcontracts. Is it potential subcontracts for this procurement? The potential subcontractors of this procurement? Is it potential subcontracts that I, as an offeror, and every other affiliate and my clients might have? I don't know what is meant by potential subcontracts. And so you also have to not disclose something that's inconsistent with the securities laws, but you have to give the name of the client and a description of the services rendered or planned to be rendered. The nature and extent of the financial or other interest. And then if something in that disclosure changes, you have 5 days. Now, I think that this is impossible and will create gotchas that somebody somewhere will say, oh, there's an interest, or you only gave things that you have actual contracts for, but it says currently planned. So if you're even thinking about going after business in any area, and then the disclosure is of some of the probably most sensitive, proprietary, commercially sensitive information you can imagine for a company that does both government and commercial work. And then the 5 days, I mean, I could go on, but I'm going to try to keep it limited here. The 5 days, I think, an OCI is not like, I don't know, did you make a filing on X day or not? It is a complex question whether an OCI exists. You have to look at the statement of work, you have to have legal analysis, and then here you're talking about a very broad swath of, you have to know what your affiliates are up to, you have to know what commercial and government work is up to, you have to make sure you don't violate the SEC laws, and you have to do all of that within 5 days. Let's say, you good faith try to do that within 5 days. Some disappointed offeror says, well, the 5 days, you actually took 10 days. Are we going to be creating just a gotcha protest system by having so many vaguenesses in here that people can use it not for the intent of protecting the government's interests, but for the purposes of a litigation advantage? And so I would counsel that, as industry looks at this and the FAR Council looks at this, that we try to make the rules address really what we're getting after. And I pity the poor contracting officer who gets a disclosure that is literally compliant with this from a large multinational contractor. They will be buried under a mountain of information that will be extremely difficult to assess. And that's just one person's opinion.
All right, Chris, you're up.
Thank you very much. So just to follow up on Carl's last point, with regards to a multinational making disclosures, this is one of several regulatory initiatives we're seeing internationally where multinationals will have to bring together information from many, many different jurisdictions. I agree with Cara. Very serious questions about the breadth of these required disclosures. I think we'll talk about those some more. But as an example, the foreign subsidies regulation, which the European Union has in place, requires contractors for civil contracts over 250 million euros to disclose any foreign government subsidies that they've received. The Trump administration has signaled that it's going to impose the same type of requirement on contractors coming into the U.S. marketplace. They've specifically signaled that in the order that the president issued shortly after he took office a few hours later. So we're going to see multinationals having to quickly gather information from many, many different jurisdictions to answer these types of questions. There are two things I wanted to talk about. And the first one is on the international side. What tends to go underappreciated here is that while the United States has been in the lead in the OCI regulations, we've had OCI regulations since the Kennedy administration for about 60 years. The other nations are rapidly putting organizational conflict of interest rule systems in place. And there's actually very little discussion going on between jurisdictions, which creates a real problem for the contractors that have to now comply with multiple jurisdictions. One of the things that Jessica and I point out in our anti-corruption teachings is that the compliance systems, the compliance requirements are all the same. Compliance system requirements are all the same all over the world. And the FCPA guidance is issued by the Justice Department and the Securities Exchange Commission. The FCPA guidance at page 56 specifically says that compliance systems are the same all over the world. The question is whether or not we should make OCIs, which are also a risk mitigation measure, very closely tied to compliance systems, whether or not OCI law should be more consistent, maybe through trade agreement or otherwise. By happy fortuity, these things tend to, I think it's because the systems are addressing the same problem in the same ways. Article 57 of the EU directive, 2014/24/EU, Article 57 on the court and the decisions of the Court of Justice for the European Union, Fabricom several years ago, most recently Infrastructuras, which is a Portuguese case before the court in a decision in 2023. The decisions of the Court of Justice for the European Union look very much like what American law is. They treat this as a qualification question. They're calling for a dialogue between the contracting official and the contractor about the risk that's posed. They're taking a risk-based approach. That's a major breakthrough. They're taking a risk-based approach, as the Organization for Economic Cooperation and Development has suggested, that contracting should be a risk-based exercise, should not be a check-the-box, legalistic, formalistic exercise, but a risk-based exercise. So we're on the same track, but there's not enough discussion going on. Now, with regards to the international realm, I want to highlight an issue that popped up over the last year, and it's becoming more and more acute issue, which is that as nations are developing organizational conflict of interest laws, they are trying to apply them to what we would call a conflict of commitment. They're trying to apply OCI rules to situations where, for example, a consultant is working both for the People's Republic of China and the United States at the same time. Technically, you could try to apply OCI rules to that, but it doesn't work very well, partly just because nations don't want to engage in the same kind of communication with contractors about sensitive national security or diplomatic issues that they would in a contracting issue. There's a really conflict of commitment. What's interesting is that the United States is separately developing conflict of commitment laws. There was a call for the Defense Department to do that. The Defense Department issued a proposed rule on consulting services that would have to do with that where if a consultant worked both for China and the United States, that would raise serious problems. So, and those rules are now being renewed. There were proposed rules issued late 2024, and now that process appears to be restarting. But those are conflict of commitment questions. And I would recommend that as the law moves forward, we treat them separately. OCIs, organizational conflicts of interest versus conflict of commitment, which are more difficult to deal with. These issues that we learn from the international comparative space also give us a lot to think about in the state space. I'm the academic advisor to the Model Procurement Code process. When the Model Procurement Code is being updated, the 2000 version is being updated now by the American Bar Association, the National Association of State Purchasing Officials. And other stakeholders. We're working on revising the NPC. And the problem is that the Office of Management and Budget, in its guidance to federal grantees, requires grantees, not the states, but the other grantees, to have organizational conflict of interest policies in place. And the question is the law settled enough for the grantees to be able to do that? And I would argue, including on this proposed rule, no, the federal law is still in flux. So for the OMB to wag its finger at the grantees and say you have to have an organizational conflict of interest policy in place is really, I think it's a good idea generally, but we have to proceed with real caution because there's so many questions that have to be resolved. First question, I think we'll be discussing this in a few minutes. Coverage, okay? If you look at the organizational conflict of interest, the proposed rule, it wouldn't cover products. This is craziness, okay? Organizational conflict of interest rules have covered products since the 1960s. To break it off and say, we're only going to cover services, what kind of lesson is that sending to our counterparts at the state and local and tribal level? Moving the rules from FAR Part 9, which governs qualification, to FAR Part 3, which covers anti-corruption. This is something that Jessica's been pushing for. I think it's a great idea. I think it's absolutely fine as long as we realize that as we're shifting it from 9 to 3, by the way, Dan Gordon pushed for this as well for many years. As we move it from 9 to 3 to the anti-corruption section, we have to remember that it really is a question of contractor qualification. It's a question of risk mitigation. And so you have to, normally anti-corruption, people say, oh, you're corrupt, you're out. Okay, that's not what OCIs are. OCIs are about a discussion. And in fact, the proposed rule contemplates that. It continues to contemplate full engagement between the contracting official and the contractor. That's very, very important. But again, as we're sharing lessons with our counterparts at the state and local and tribal level, we have to make clear, yeah, we're moving it from qualification of FAR Part 9 over to anti-corruption FAR Part 3, but we're still going to deal with it as a very intense communication back and forth. The standard clauses anticipate, really, Cara pointed out this incredible amount of information that has to be disgorged by the contractor as part of these standard clauses. Well, most state and local procurement is a heck of a lot more transparent than the federal procurement system. So if we encourage and require the state or local grantees to have the same standard clauses, and we force the same disclosure, it's going to cause havoc from a proprietary standpoint, because all that information is then immediately available to the public, because that's how things run at the state and local level. In a very healthy democracy, it's a good idea to have that kind of transparency, but the standard clauses just wouldn't work. The waivers, the waivers that's in the proposed rules are tighter, but not as tight as the National Defense Authorization Act, Section 881. Section 881 of the National Defense Authorization Act requires the FAR, and this is still sort of hanging in the limbo here, requires the FAR to be tightened under 9.5 to tighten the waiver requirements. How are we going to share that lesson when we still can't decide at the federal level how waivers should be handled? We're still up in the air. So these are a lot of very serious questions that the proposed rule raises, that the back and forth of the federal level have raised. These very open questions make it much harder to dictate what those OCI provisions should look like at the state and local level for grantees, and what it should look like in the model procurement code. Thanks a lot, Jessica.
No problem. Thank you for that. And I will, mindful of the fact that we have an hour, I will give just my brief reflection on it. I will just say I, as Chris already mentioned, I am very pleased to see that we've moved OCIs out of FAR Part 9, given that this is, again, an issue of conflicts of interest, which I think appropriately resides in Part 3. And I will also note, for anyone who is worried that this would be purely pegged as a anti-corruption issue, that the proposal doesn't include renaming the entire section of Part 3 to business ethics and conflicts of interest, which I think is quite broader. And I actually like that approach, which really does embrace kind of the compliance atmosphere associated with Part 3. So I think that's good. A few things that I wanted to raise before we do another kind of round robin, and then we open it up to questions. And thank you. We're seeing your questions in the Q&A. Keep them coming. We appreciate that. One of the ones that I've seen, and I think Cara and I can have a little bit of disagreement on the clauses. I appreciate the issue of the amount of information and sifting through the information. I think all of us recognize that the breadth of the clauses is quite broad. But that said, I think currently we're seeing an uneven practice among agencies, given that they're relying on this patchwork of some agencies have the clauses, some don't. Some are broader and have continuing obligations, some do not. So if one of the goals of our procurement system is uniformity, having some greater uniformity, it feels to me like a very low bar to just add a standard clause and solicitation provision. I do believe that we're going to need some significant training to coincide with this, not just from the federal level and how contracting officers can be trained with regard to this, but also I foresee significant training on the private sector side as companies begin to adapt to this new framework. One of the ones that I wanted to mention that I think is really critical that we haven't talked about as much, because I think the focus is on the bulk of these types of cases, is the emerging issues. And one of the issues that has continuously arisen in all my conversations when I've had to testify, whether it's the McKinsey hearing in front of the House Oversight Committee, or it was the Senate dealing with foreign conflicts of interest, is that there were greater and emerging risks that this rule needs to adapt to, and that the messaging that keeps coming out from conversations and experience discussing these issues with contracting personnel is that they don't feel like they have coverage or comfort from the existing framework. And so I think one of the bigger concerns, for example, is that, you know, if you're dealing with contractors that are in the national security space and have a contract in, you know, with a foreign adversary, are they giving unbiased advice to the United States government? And we've seen examples in the United States and internationally where that might not necessarily be the case. And we're hoping that this rule will help address that or provide government officials the comfort that they need in order to address that. One of the other ones I want to raise is obviously the commercial conflicts of interest. So that is why it's broader. And I know that this gives Cara a heart attack with the broadness of it, but it's meant to address the issue that first arose during the House Majority Oversight investigation into McKinsey's potential conflicts with the FDA. And that, again, it's broader because we started to see that contracting officers weren't necessarily seeing those as potential OCIs, which created a reputational risk for the government. And the third one, which people aren't focused on and isn't necessarily captured, is the emerging risks associated with artificial intelligence and whether or not the data used to train AI models or the algorithm could be biased. Could the AI be biased, or the system be biased in a way to preference a contractor in a future competition? Because we know that the government's increasingly using artificial intelligence in its procurement processes. So could the machine have the OCI? My only point is that we haven't updated this in decades, and there needs to be some sort of way to address these things. And I think the rule does a pretty good job of it. But I want to get back to the product issue that Chris mentioned. Ken, in your experience, I know you can't speak to future procurements. In past procurements, you know, do you know if we've saw a significant number of cases involving products, or is it mostly in the kind of services where we're asking the contractor to exercise judgment? Could you speak at all to, like, in past, where we've seen most of the concern in past OCI cases?
Absolutely. Actually, yeah, as you sort of hint at, most of the cases concern services. That's by far the vast overwhelming instance where people have concerns about conflicts of interest, providing advice and assistance and conflicting roles and responsibilities. We do have had one or two instances where there's a higher question about the provision of products. And that, again, it still kind of goes back to, are you favoring your product? Is your objectivity impaired because you're going to make recommendations to the government about some downstream product that you are in fact going to sell? Is an affiliate going to sell this type of product? So the issue of products does come up in organizational conflicts of interest, and it mainly comes from whether or not the contractor is conflicted because they're going to be biased in favor of their particular product, or it's come up in the instance where a contractor might sort of disadvantage its competitors and sort of give information to the government that advantages itself or disadvantages its competitors. So looks like Chris has a response. Chris? Oh,
No, I completely agree with you, Ken. No, so I was trying to figure this out about this exception for commercial products, and then I looked back at the DFARS proposed rules, Jessica, and everything became clear. There is no authority in the legislation, the NDA provision that created the DFARS, or in this legislation for this proposed rule for taking such a crabbed approach. And yet consistently the rule writers do this. Consistently the rule writers are trying to create this little tiny avenue of application, arguing that's because they have to respect the fact that commercial item contracts cannot be overregulated. And that's an ongoing separate debate whether or not, for example, all the statutory requirements that have been piled into FAR 52.212-5 for commercial items, whether or not they need to be swept away. That's a separate debate. What's happening is the rule writers are using that debate as a weapon to limit the application of these OCI rules. You can see a pattern here. If you look just like the proposed rule, it's hard to see the pattern. But if you look rule after rule after rule, they're taking a very narrow approach without statutory foundation. I don't think that this division is going to hold up under a local right analysis. Maybe in the old days there would have been deference to the regulators, but after the Supreme Court's decision and local right, even if you look back at Kaiser, the earlier decision, the 2019 decision that talked about the way that agencies approach their own regulations, there's not deference when there isn't a statutory support for this type of narrow crabbed approach, especially when the agencies have a self-interest in taking a certain approach. In this case, it looks like the rule writers are trying to avoid the application of OCI rules, which, well, those, Kara and I can say as a matter of practice, that's been going on for years. The overuse of the waiver authority is about the agencies trying to avoid any OCI problems. Here, the rule writers appear to be taking a crabbed approach and saying it only applies to commercial services in order to avoid being touched by these OCI rules. And that kind of self-interest cannot survive in a local right universe.
Couldn't find my mouse for a second. Mike, and thank you for that, Chris. Mike, I want to jump back to you and Cara on this issue, which is this issue of disclosure requirements and the obligation that it places on COs to identify these issues up front. It's actually reflective of one of the questions we got in our Q&A.
Yeah, thank you. I think Cara made a great point with respect to sort of the vagaries and the unclarity, if that's a word, of some of the provisions in the new clauses. But it's not just a disclosure issue for the contractors. It's an issue for the contracting officers as well, because before you even get to, primarily what the disclosure rules are getting after is when a contractor has new information, maybe post-award, whatever the case may be, they're supplementing what's previously been provided. But the new rule places the impetus on the contracting officers all the way back to the acquisition planning stage to incorporate these considerations and to go figure out if any of the actual officers or offerors, or potential offerors might have a conflict of interest. And the universe of that, especially when you think about something like what is an other interest, could be extraordinarily broad. What might come to you in a supplement after, further down the road will at least be narrower, but the entire universe of the contractors, affiliates, subcontractors, clients, all of the things Cara pointed out, that entire universe is out there, and contracting officers are now required to go find it. And in a lot of cases with potentially with information that it just isn't readily available to the government. If anybody who's been around defense contracting for a minute knows that, the corporate structures and the organizational relationships, it's very complicated and very dense. And I won't speak for anyone else, but for me personally, difficult to understand. And sometimes just chasing down who owns who and who does what can be very difficult. So, and that raises, in my mind, as a government practitioner, that raises some litigation risk, because, what if we miss something and then, it's not hard to imagine a scenario in which there is some other interest out there that we didn't catch that ends up, before GAO or the courts in litigation. So I certainly appreciate the disclosure risk, or the risks inherent in the disclosure requirements of the contractors, but the rule also creates new risks on the government side as well.
Yeah.
Cara, do you want to take do you have that, or do you want to take a different question?
I'll take whatever question you want. I mean, in looking at the clause, the CO, at least in the 52203-XX one, is supposed to identify who's disqualified because they have a limitation on future contracting clause, and then who's disqualified because they may have participated in preparation of the statement of work or other requirements documents. That to me sounds like a biased ground rules OCI. So on the one hand, if the CO says these people are the ones that participated in the drafting of the solicitation and they are therefore disqualified, on the one hand, I would hope that that would put a pin in it for any disappointed offeror coming in and saying, oh, well, you could have done it, somewhere over here. I mean, I cannot tell you the number of bid protests that I have been involved in where despite, an agency saying, we think there is somebody coming in and saying you wrote part of the statement of work simply because you might have done some contract somewhere for the agency, even if the agency says that isn't so. So maybe that will help. I'm not so confident because I think we'll still see protesters saying, well, you missed one. And that's my concern with the disclosure. Well, you missed one. There's another. There's another. There's another. And you can always, manufacture something if you want to upend a procurement, and that's my concern about that is it puts it let's not make it more protesty. I think the idea is to make it a little less protesty. I want to just I don't want to take issue with what Chris said, but I do want to put another side to what Chris said. There's FASA out there. That is a statute. And so what they are doing is arguably consistent with FASA. You might believe it's not consistent with the Preventing Organizational Conflict of Interest Act, but there's a competing statute that says you will, try to promote and not put burdens on and only do certain clauses and things like that. So there is a competing interest there. I think having a waiver system, and one part of this rule that I, in my personal capacity, is this idea of being able to accept the risk. I think having waivers and being able to accept the risk brings a common sense element to the rule, so that the agencies are not constantly, in a gotcha position, that there's some little tiny potential feasible, okay, it's potential, but just like we don't convict people just because speculation or they potentially committed a crime. I think we need to have that common sense element in there, and so I do believe agencies should have those tools in their toolbox. Whether or not they are abused, I think people could disagree. I don't see waivers. They're more than they used to be a few years ago, but I don't see them handing them out like, candy at Halloween.
Ken? You're muted.
Thank you. You think after years of doing this, I would have figured that out by now. But thank you. And actually, I just wanted to add up another perspective to the panelists' views on I think it's, for me, the value of this particular new rule. Contracting officers in the past have always had to exercise independent judgment, obtain all the facts, figure out what the right mitigation strategy ought to be, determine whether or not there are existing or further conflicts. I think what this new rule does is it incrementally gives them more tools in the toolbox to be able to make those kinds of analyses. Are there gaps? Are certain terms vague? Maybe. But I think that still gives the contracting officer a lot of discretion and the ability to sort of dig down and make an informed decision using hard facts to make their case, to say, hey, I can mitigate this or I can accept that. I don't think there's ever going to be a rule that's so detailed enough that's going to eliminate all the risks that could potentially happen from any type of OCI that's out there. Contracting officers are still going to need to consult counsel, get information from their contractors, offerors, and make an informed decision. And I think this rule gives them a groundwork and a framework for making those assertions and getting that information to reaching a conclusion. So just my 2 cents.
So thank you, Ken. And so looking at some of the questions that are coming in, some of them relate to mitigation plans and what constitutes sufficient mitigation. For example, the role of firewalls, which in some instances has been enough, but in many others, it's viewed as not sufficient. And Cara, I'm going to bring this back to you because you regularly advise clients, or you and your colleagues advise clients on these issues. What, if anything, do you see that this rule does with regard to the issue of mitigation?
Well, I think mitigation is always a fact by, case by case thing, not one mitigation plan fits all. Traditionally, under GAO's case law, at least, firewalls were a recognized mitigation strategy for the unequal access to information type OCI. And firewalls were not deemed an adequate mitigation strategy with respect to bias ground rules or with respect to impaired objectivity. I mean, I could imagine a scenario where, I don't know if GAO would change its case law, if this rule were to come to pass, but I could see that a particularly vigorous firewall between affiliated entities could. I think the concern with the firewall, let me drop this back, because as I was saying this, I'm now disagreeing with myself. I think the concern with an impaired objectivity OCI, and again, I'm looking at this like I'm putting on my professor hat, okay, not my contractor counsel hat. Yes. Is that affiliate is doing providing a service over here, and affiliate over here might be evaluating it. You could firewall those two affiliates such that they're not sharing information, and right hand and left hand don't know what the other is doing. But the concern is that I will want the affiliate to do well from a financial standpoint because it will raise all ships within our corporate organization. And so I don't know that is necessarily that is a different kind of concern than a unequal access to information, that I'm getting information that helps me compete. This is more of, can you be impartial? Can you be impartial, right? And so that, I would just say, traditionally the case law, that's why they have not accepted a firewall, because it's about impartiality rather than an unfair competitive advantage. Now, can that be waived? I do agree that, an impaired objectivity OCI is probably one that's ripe for being waived because the interests might be, in a particular factual scenario, really attenuated.
Chris, did you have something you wanted to add? Yeah, go ahead, Chris.
Yeah, it's actually a question for Cara, because I think it cuts across a lot of the questions. So Cara, I was arguing for, if we look at compliance plans, and the compliance plans are going to be uniform across industry, uniform across the world. In fact, there's a lot of public pressure to make compliance plans uniform, to make them public, so that other people can look at them and see whether or not they meet industry standards. Is it possible, Cara, just to have a compliance plan here, and you add a chapter called OCIs, And if that's true, if there are accepted compliance/OCI plans in industry, could we be moving towards a day 20 years from now where we have really standardized approaches to compliance/OCI across an industry, and that the contracting officer, while this is really a contracting officer risk assessment, the contracting officer has to defer to those industry standards, because those industry standards are true across industry, and imposing different standards would be highly inefficient. So one of the questions we had, one of the questions you posed earlier on in terms of the disclosures, I was listening to it and I thought, a standard law firm conflict of interest check wouldn't pick up all these things that Cara is saying. Should this be part of the mix? Should what industry is doing on a standard basis for compliance/OCIs be part of the mix? Because the contracting officer otherwise is creating a new risk called anti-competitiveness.
One thing I just want to temper, I think legitimate concerns about the amount of information that's being shared and the type of information shared and the amount of compliance resources that will need to be dedicated to detecting or determining what's a financial. One way to cabin this, though, is to remember that if a financial interest, and again, I'm not underplaying like the amount of resources it'll take. One way to put this in its own box so that it doesn't get out of control is that a few things. One, if the contractor can't even realize that it's a conflict of interest based on training and based on greater illustrative examples or other sort of things, I think it's obviously not necessarily going to be identified. And I think that it is unlikely, potentially, that the contracting officer would be able to identify it. And if it's so difficult for even the contractor to potentially identify it, I also think you're not as worried about either some of the adverse consequences of not identifying it, right? And we're talking about things that are so difficult or so remote that they can't. Now, somebody in here is probably watching and going, but what about the False Claims Act? Well, there's a knowledge standard. And I would argue that you'd have a fairly difficult time bringing or succeeding, well, maybe anybody can bring it, succeeding if you can't even demonstrate that you were reckless. If it was so difficult to find it, that, that they were reckless and not identifying it. Again, that would be litigated out in the FCA space, but I would have a hard time seeing somebody bring a successful FCA action on something that is so either remote or so difficult to identify at the outset that it couldn't be in the initial disclosure. I appreciate that that's a lot, and contractors already struggle with these issues, but I'm just pointing out that I think if it's this conflict all the way over here, we're not necessarily going to see it. I also want to point out that oftentimes when we see regulation, there's initial reflexive of all the potential world of hurt that could come from it, without the kind of counterweight to the necessity. And that leads me to one of my contracts, and you should see the Q&A is blown up right now. The necessity of it. And somebody asked, well, why are we even doing this? Well, part of it is that we have been operating in a completely different universe, and due to massive amounts of outsourcing over the last several decades, the OCI rules just haven't caught up to kind of the newer risks. And I already identified some of the emerging risks. Somebody asked, should we do this with a different framework? Maybe. And frankly, the conflicts at FAR Part 3 are broad enough to capture some of these things. But a lot of these cases that bring such significant reputational harm to the government are things that should have been caught, and actually, frankly, could have been caught under even the existing framework. But I think the goal was to provide more guidance to the government, to provide more uniformity, and to address kind of some of these growing risks so that it's more reflective of modern procurement practices than what we've seen. We are actually at the hour, so I just congratulate myself in giving myself the last word. I'm so sorry for that, guys. If anybody had a burning statement and wanted to scream lies, you didn't get that. But clearly there's more to come on this. We are currently in a regulatory hold, so it's unclear kind of when this picks up again, but I believe proposed the comments are due the 17th, correct, of March? March 17th, proposed comments are due. So go ahead and submit those if you have some thoughts. Some of these things identified in the Q&A sure would be great to have in the comments, and I'm sure the FAR Council would appreciate your viewpoints on these issues. So with that, I thank everyone for joining us. The recording of this will be on our YouTube channel, and now, as of this week, your favorite podcasting app. So it will be uploaded to, Apple and Spotify and among others if you want to listen to this on the go. So with a thank you to our panelists, thank you everyone for joining us, and I hope everybody has a great afternoon. Thanks, everyone.